The invoice arrived on a Tuesday morning, buried between my electric bill and a grocery store circular, demanding payment for legal fees I never authorized. I'm Colin 34, a logistics developer who moved to Brook Crossing in Clearwater Hills, Illinois 2 years ago for the quiet suburban predictability. The kind of place where property lines matter and HOA meetings run like clockwork. Where neighbors wave from driveways and disputes get resolved over coffee, not courtrooms. The letterhead read, Hartwell and Associates, Property Law Specialists. The amount, $3,247.50. The description, legal consultation and document preparation services regarding property boundary dispute resolution and HOA compliance matters for 1247 Maple Ridge Drive. My address. I read it twice, then a third time. The invoice detailed 12 hours of consultation, survey document review, and correspondence with the Clearwater Hills Municipal Planning Department, all dated over the past 6 months. All services I never requested. I called Hartwell and Associates immediately. The receptionist confirmed the invoice was legitimate. Someone had retained their services on my behalf for an ongoing property dispute with my neighbor at 1245 Maple Ridge Drive. The person who hired them had provided my contact information and agreed to handle all billing arrangements. Who authorized this work? I asked. I'm sorry, but I can only discuss account details with the client who retained our services. I'm the homeowner. This is my property. Sir, you're listed as the beneficiary of services, but not the contracting party. I hung up and walked to my front window. The house at 1245 Maple Ridge Drive belonged to Anders Moore, our neighborhood watch coordinator, a retired insurance adjuster who'd lived in Brook Crossing for 15 years. The man who'd welcome me to the neighborhood with homemade cookies and a detailed explanation of our HOA's architectural review process. Anders was trimming his hedge, the same meticulous routine he performed every Tuesday morning. He looked up and waved. I waved back. The invoice trembled slightly in my hand. Someone had been fighting a legal battle in my name, using my property as collateral, for 6 months. Someone who knew enough about my situation to convince a law firm they had authority to on my behalf. I pulled out my phone and called the Clearwater Hills Planning Department. After 20 minutes of transfers, I reached someone who could access property records. Yes, they confirmed there had been multiple inquiries about 1247 Maple Ridge Drive, boundary surveys, setback requirements, easement documentation, all initiated by concerned parties citing potential HOA violations. Can you tell me who made these inquiries? I'd need to pull the specific request forms. Most came through our online portal, but I see several phone calls from your neighborhood watch coordinator. Very thorough gentleman, really knows his municipal codes. My stomach dropped. Anders Moore had been making inquiries about my property for months. The same Anders who'd helped me understand the HOA's landscaping requirements when I first moved in. Who'd offered to review my fence installation plans before I submitted them to the architectural committee. I ended the call and stared at the invoice again. The dates aligned perfectly with a series of minor issues I'd experienced over the past 6 months. A citation for my garbage cans being placed too early. A warning about my mailbox height. A request to trim my oak tree because it allegedly violated the sightline ordinance. Each issue had been resolved quickly thanks to Anders' helpful guidance. He'd known exactly which forms to file, which departments to contact, which codes to reference. I'd been grateful for his expertise. Now I wondered if his expertise had been working against me all along. I needed to understand how deep this went. The next morning, I drove to the Clearwater Hills Municipal Building on Jefferson Avenue. The records department occupied the entire second floor, fluorescent lights humming over rows of filing cabinets and computer terminals. The clerk, a woman in her 50s with reading glasses hanging from a beaded chain, pulled up my property file on her monitor. Quite a bit of activity here, she said, scrolling through entries. Boundary disputes, easement questions, architectural violations. Your neighborhood watch coordinator has been very diligent. Can you show me the specific requests? She printed 17 pages of inquiry forms, phone logs, and email correspondence, all bearing Anders Moore's name and contact information, all claiming to represent my interests as a concerned neighbor, helping resolve potential violations. The pattern became clear as I read through the documents. Anders had been systematically creating problems, then positioning himself as the solution. He'd file anonymous complaints about my property through the city's online portal, then call me within days offering to help navigate the bureaucratic response. The garbage can citation came after he'd reported repeated early placement violations at my address. The mailbox height warning followed his inquiry about non-compliant postal installations in the Brook Crossing district. The tree trimming request emerged from his detailed report about sightline obstructions affecting pedestrian safety. Each manufactured crisis had generated paperwork, phone calls, and administrative costs. The legal fees weren't for defending me. They were for the disputes Anders had created while claiming to on my behalf. I drove to Hartwell & Associates, the law firm listed on the invoice. Their office occupied a converted Victorian house on Elm Street, 3 blocks from the municipal building. The receptionist confirmed that Anders Moore had retained their services 6 months ago to handle property disputes for 1247 Maple Ridge Drive. He presented himself as your designated representative, the paralegal explained when I requested copies of all correspondence. He had detailed knowledge of your property specifications and HOA requirements. We assumed you'd authorized his involvement. The file contained 43 pages of letters, motions, and administrative appeals. Anders had hired Hartwell & Associates to fight every citation and violation notice he'd generated through his anonymous complaints. The firm had billed $4,200 in legal fees, believing they were working to protect my property rights. But Anders had never paid the bills. Instead, he had provided my contact information as the responsible party, claiming I'd handle payment directly. The invoice I'd received was the firm's attempt to collect from their actual client. I spent the afternoon at the HOA office, a small suite in the Clearwater Hills Community Center. Kinsley Moore, the administrative assistant, pulled the architectural review files from our property, no relation to Anders, despite sharing a surname. Your neighborhood watch coordinator has been very involved in the review process, she said, spreading documents across the conference table. He submitted detailed reports about potential violations throughout the Brook Crossing district. The reports painted a picture of systematic harassment disguised as community service. Anders had documented every minor deviation from HOA guidelines, photographed property modifications without permits, and filed formal complaints about landscaping choices that allegedly violated the community's aesthetic standards. But his reports weren't limited to my property. He'd been targeting 6 other homeowners in our section, all recent arrivals to the neighborhood, all people who trusted his guidance when navigating HOA requirements. Has anyone else received unexpected legal bills? I asked. Kinsley checked her computer. We've had several inquiries about unauthorized legal representation. Homeowners receiving invoices for services they didn't request. The board is investigating. I left the community center with copies of Anders' violation reports and a growing understanding of his operation. He'd been using his position as neighborhood watch coordinator to access property information, identify vulnerable homeowners, and create legal problems he could profit from solving. The scheme was elegant in its simplicity. Generate anonymous complaints through city channels, offer helpful guidance to confused homeowners, then hire legal representation while claiming authority on their behalf. The victims would be grateful for his assistance, while unknowingly accumulating legal bills for disputes they never authorized. That evening, I called Detective Reese Chen at the Regional Consumer Protection Watchdog panel. Her office handled insurance fraud cases, but she'd recently expanded into HOA-related financial crimes. This sounds like a pattern we've been tracking, she said after I explained the situation. Neighborhood watch coordinators have access to detailed property information and homeowner contact data. Perfect position for this type of fraud. She requested copies of all documentation I'd gathered. The legal invoices, city inquiry forms, HOA violation reports, and correspondence from Hartwell & Associates. She also wanted contact information for the other targeted homeowners. We'll need recorded of his admissions, Detective Chen explained. If you're willing to cooperate, we can set up a controlled conversation where you confront him about the legal bills. Get him to explain how he justified hiring attorneys on your behalf. I agreed to wear a recording device during my next interaction with Anders. The plan was simple. Approach him as a confused homeowner seeking clarification about the unexpected legal bills, then let him explain his involvement. 2 days later, I walked across the street to Anders' house. He was pressure washing his driveway, the same methodical attention to detail he applied to everything in his life. He shut off the machine when he saw me approaching. Colin, good to see you. How are things going with those property issues? Actually, that's what I wanted to discuss. I received some legal bills from Hartwell & Associates. They claim you hired them to handle disputes about my property. His expression didn't change, but I noticed his grip tighten on the pressure washer handle. Oh, that. Yes, I thought it would be helpful to get professional guidance on those violations. The city was being quite aggressive about enforcement, but I never authorized you to hire attorneys on my behalf. Well, no, but you seemed overwhelmed by all the paperwork. I have experience with these municipal processes. I thought I was helping. The recording device captured every word as Anders explained his reasoning. He'd seen how confused I was about the various citations and violations. He'd taken initiative to protect my interests, assuming I'd appreciate his proactive approach. The legal fees were a necessary investment in resolving the disputes efficiently. He never mentioned that he'd generated the disputes himself, never acknowledged that his anonymous complaints had created the problems he'd hired attorneys to solve. In his version of events, he was a helpful neighbor who'd overstepped boundaries while trying to assist a fellow homeowner. But his explanation contained enough admissions to establish fraud. He'd hired legal representation without authorization, provided my contact information as the responsible party, and accumulated bills in my name while claiming to on my behalf. The conversation lasted 20 minutes. Anders grew increasingly defensive as I pressed for details about his authority to hire attorneys, his knowledge of the specific violations, and his expectation that I would pay for services I hadn't requested. By the HOA, he was suggesting that good neighbors help each other navigate bureaucratic challenges, and that I should be grateful for his expertise rather than questioning his methods. I thanked him for his time and walked back to my house. Detective Chen would have everything she needed to build a case. The recorded conversation, combined with the documentary, painted a clear picture of financial fraud disguised as neighborhood assistance. But as I reached my front door, I realized the investigation was just beginning. Anders had been targeting multiple homeowners, accumulating legal bills across the Brook Crossing district, while positioning himself as an indispensable community resource. The scope of his operation was larger than I'd imagined, and the recording device had captured his admission that he'd been making these decisions for other neighbors as well. Detective Chen reviewed the package within 48 hours. The recorded conversation, combined with the forged authorization documents and billing records, established a clear pattern of fraud. She scheduled a meeting at the Clearwater Hills Police Department for the following Tuesday. The conference room contained 3 other homeowners from Brook Crossing. Kinsley Moore from Maple Ridge Drive had received $3,200 in legal bills for tree removal disputes she'd never authorized. Anders Whitfield from Oak Valley Court faced $2,800 in fees for fence line litigation he'd never requested. Kinsley Patterson from Cedar Brook Lane owed $4,100 for drainage easement consultations she'd never approved. Each homeowner brought identical documentation, forged authorization letters bearing their signatures, legal bills addressed to their properties, HOA violation notices that had triggered the supposed need for legal representation. The pattern was systematic and extensive. Detective Chen explained the investigation process. Financial fraud cases required coordination between local police, the Illinois Attorney General's Consumer Protection Division, and the Regional HOA Oversight Board. The suggested violations of the Illinois Consumer Fraud, specifically Section 815 ILCS 505 halves, which prohibited deceptive practices in consumer transactions. She'd already contacted the law firms that had generated the bills. Hartwell and Associates confirmed they'd been hired by someone claiming to represent multiple Brook Crossing homeowners. The retainer agreements contained forged signatures and falsified contact information. The firm had attempted to collect payment from the homeowners directly after their supposed representative became unresponsive. Morrison Legal Group provided similar information. Their client had presented himself as a neighborhood watch coordinator with authority to handle legal matters for residents facing HOA violations. They generated $18,000 in billable hours across 7 different cases before discovering the authorization fraud. The investigation expanded when Detective Chin contacted the Clearwater Hills HOA Management Company. Their records showed that Anders had filed 43 violation complaints over the past 18 months. Each complaint had triggered inspection processes, citation procedures, and potential legal action against the targeted homeowners. The management company's database revealed the scope of his operation. Anders had systematically reported minor infractions, mailbox height violations, lawn maintenance issues, exterior paint color discrepancies, and fence placement disputes. Each complaint had generated administrative costs and potential legal exposure for the homeowners. But the most damaging discovery came from the city planning department. Anders had requested property surveys for 12 different addresses in Brook Crossing, claiming to represent the homeowners in boundary disputes. The surveys had cost $800 each, billed directly to the property owners without their knowledge or consent. City records showed that Anders had used his position as neighborhood watch coordinator to access homeowner contact information, property records, and HOA violation histories. He'd leveraged this information to create artificial legal problems, then positioned himself as the solution provider. The Regional Consumer Protection Watchdog Panel assigned investigator Sarah Martinez to coordinate with Detective Chen. Martinez specialized in HOA financial fraud and had seen similar schemes in suburban developments across northern Illinois. The pattern typically involved trusted community figures exploiting their access to homeowner information for financial gain. Martinez explained the Anders scheme violated multiple statutes. The Illinois Uniform Deceptive Trade Practices prohibited false representations about authorization to on behalf of consumers. The state's identity theft statute covered the unauthorized use of homeowner information to generate legal obligations. The consumer fraud addressed the deceptive billing practices. The investigation required careful documentation of each fraudulent transaction. Detective Chen and Martinez worked with the affected homeowners to compile comprehensive packages. Each case needed detailed timelines, financial records, and proof of unauthorized representation. I spent 3 days organizing my documentation. They included the original HOA violation notices, the forged authorization letters, the legal bills from both law firms, email correspondence with Anders, and the recorded conversation from our final meeting. The package also contained photographs of my property showing compliance with all cited violations. The other homeowners provided similar documentation. Kinsley Moore's tree removal dispute involved a perfectly healthy oak tree that met all city ordinances for size and placement. Anders Whitfield's fence line litigation concerned a boundary that had been professionally surveyed and approved by the city planning department. Kinsley Patterson's drainage easement consultation addressed a non-existent water management issue. Detective Chen scheduled individual interviews with each homeowner to establish the timeline of Anders' deception. The interviews revealed his methodical approach to building trust before exploiting his position. He'd spent months establishing himself as a knowledgeable resource for HOA compliance issues, offering advice and assistance to new residents. The breakthrough came when Martinez discovered Anders' financial records through a court-ordered subpoena. His bank statements showed deposits from legal fee reimbursements that he'd collected from some homeowners before they realized the charges were fraudulent. He'd convinced 3 residents to pay partial amounts while he negotiated with the law firms for reduced settlements. They also revealed that Anders had been collecting finder's fees from some of the service providers he'd recommended to homeowners. Tree removal companies, fence contractors, and landscaping services had paid him referral commissions for business generated through his violation complaints and subsequent recommendations. His scheme had generated approximately $47,000 in fraudulent legal bills across the Brook Crossing district. He'd collected $12,000 in direct payments from homeowners and $8,000 in referral commissions from service providers. The total financial impact exceeded $67,000 when including the cost of property surveys, administrative fees, and homeowner time lost to dispute resolution. Detective Chen filed formal charges under Illinois Criminal Code Section 720 ILCS 517-1, which covered deceptive practices in financial fraud. The charges included identity theft, consumer fraud, and unauthorized practice of law. Each count carried potential penalties of up to 5 years imprisonment and $25,000 in fines. The case proceeded through the Cook County State's Attorney's Office. Prosecutor James Morrison specialized in white-collar crime and had extensive experience with HOA-related fraud cases. He explained that Anders' position as neighborhood watch coordinator had created a fiduciary relationship with the homeowners, making his deception particularly egregious under Illinois law. The legal proceedings moved quickly due to the comprehensive package. Anders' attorney negotiated a plea agreement that included full restitution to the affected homeowners, dissolution of his neighborhood watch position, and a 5-year prohibition from serving in any HOA leadership role. The settlement required Anders to pay $67,000 in restitution, plus $15,000 in investigative costs and legal fees. He also faced 18 months of supervised probation and 200 hours of community service focused on consumer protection education. But the most significant outcome was the systemic change to HOA oversight procedures. The Clearwater Hills Management Company implemented new authorization requirements for legal representation, mandatory disclosure of financial relationships between board members and service providers, and quarterly audits of violation complaint patterns. The Regional Consumer Protection Watchdog Panel used our case as a model for training materials about HOA financial fraud. Martinez developed a presentation that highlighted the warning signs of unauthorized legal representation and the importance of verifying service provider relationships. I worked with investigative reporters exposing HOA financial corruption to ensure other communities could learn from our experience. The story appeared in the Chicago Tribune's Suburban section and was picked up by HOA industry publications nationwide. The investigation had taken 4 months from initial discovery to final resolution, but the outcome provided justice for all affected homeowners and established precedents for preventing similar fraud in other communities.